No, I just switched. And now I'm on a felony 2 calendar. So I for any pro bono lawyers who feel like they're stepping out of their comfort zone to take on something new, I feel you. Um, okay, so I'm so happy for everybody to attend here today and get to meet so many of my fabulous colleagues. Um, Definitely, pro bono work in Superior Court involves a lot of litigation. I mean, that's what we do. But every lawyer, no matter their practice type, will benefit from the experience of handling matters in Superior Court. And we have all different sorts of work that you can take on. But I do encourage people to step out of their comfort zone, as I am now. And hopefully after today, you'll have some ideas about how you can do so. The judges here with me today will share their perspectives on the transferable skills of pro bono work at Superior Court across all different types of legal practice, from litigation to transactional, administrative law, all sorts of ways in which you can build your skills in pro bono work while helping your community members. Lack of representation at Superior Court is acute. Especially in what we refer to as the high volume courts. And those include domestic relations, where there are very serious issues related to child custody, landlord-tenant, small claims, and domestic violence. These are very important issues in which we're seeing 80+% of the litigants not having the benefit of a lawyer. So for our event here today, I'm going to act as the moderator, and we're going to have a discussion with all of the judges that you see here. We're going to keep all of the attendees muted for that discussion for around 40 minutes or so. And then we will open it up. So if you have any questions, feel free to put them in the chat, and Jody and Christina will be monitoring that and be able to ask them as they see fit. But then there will also be some time at the end to be able to ask questions directly if you'd like to do so. So before I introduce the amazing panel, just want to give you a little bit of insight into how I come at this. I was a litigator at Jones Day, but I worked on very large matters. So I spent a lot of time doing tasks that are very broadly transferable. And one of the things that I learned a lot about through my pro bono work that I then applied to my other work was client counseling. So I learned how to listen to a client, get the information that they thought was important, advise them about the law, and help them understand why I was recommending the path that I was recommending. And those skills were skills that I was then able to apply in all of my billable matters in a variety of contexts. So, and I see a ton of different skill development opportunities like that in our work here at Superior Court. So our panel, we have with us Stephen Wellner, who was previously a partner at Kirkland, where he was also the pro bono coordinator. He also worked at the EPA and OAH and has had multiple roles in different capacities at the court, from misdemeanor custody cases and otherwise. We have Laura Crane, who was both an AUSA and an attorney at Cravath. We have Deb Israel, and also has had multiple different assignments here at the court. Deb Israel, who was the chief operating partner at Womble Bond Dixon before she came to the court. And I had the honor of working with her while we were both assigned to the Domestic Relations Division doing custody cases, and now we're both on felony 2. And then we have Zeke Ross, who was at Arnold and Porter and was also an AUSA in the Civil Division of the Department of Justice, and worked as well on ethics for the House. And so with that, I would welcome them to share a little bit more about the value, as we talk, that they have seen in non-litigation skills that you can build through our pro bono work at Superior Court. So Judge Crane, you currently sit in the domestic relations branch, which primarily hears divorce and custody cases, where in most cases, neither side is represented. The best numbers we have is 80% of plaintiffs and 90% of respondents don't have a lawyer. What pro bono opportunities are available to someone who's interested in this area but doesn't necessarily want to stand up in the courtroom?
So there are lots of opportunities. I have a personal plug from my own experience in private practice. The first time I ever was able to really speak in court actually was through a uncontested guardianship proceeding that I did when I was at WilmerHale, and nothing about family law, was not familiar with family law. And it was an amazing opportunity in that it gave me as a lawyer a chance to actually do something I had never done before, but also working directly with the family that was affected was an incredibly rewarding experience. I had done a lot of other pro bono and sort of larger scale cases, but having sort of an immediate effect on the guardian in that case and the minor child was a really meaningful experience, and was really my first contact with Superior Court. So I do have very personal experience to say that without knowing anything about family law, it was very doable. It was not overwhelming. And so I certainly recommend it to anyone. So outside of sort of being directly on your feet in court, there is the Self-Help Center, which operates every single day at Superior Court. It is a really important resource that our litigants who are representing themselves have. So if they have concerns about something that's happening in their custody case, they can go to the Self-Help Center. There are trained attorneys there, and attorneys who are familiar with the subject matter area. So if you're volunteering there, there's going to be someone there to assist you who can help walk through how you're going to be able to help this litigant raise to the court what the particular concerns are. So if they need to file a motion to address a particular issue, the Self-Help Center helps them walk through laying out the facts that would help the court understand what's going on. And so it's a very discrete opportunity. So you could, do that on a particular day. And then if you can't come back for some period of time, it's not sort of a long-term commitment that I think some people may fear. I don't have enough time on my schedule to be able to say I can represent this one particular litigant. So you could pop in and do it. You also have the benefit of there being experienced people at the Self-Help Center who can help you if you said, listen, I don't know how to answer this question. There's going to be people there to serve as a resource. And so to the extent that there's a feeling of, gosh, I need someone who can kind of help guide me and make sure I'm on the right direction there. It is supervised by court staff, so you don't have to feel like you're in it without anyone there to help navigate it. And I think it's sometimes we forget as people who have a legal background how hard it is to just navigate the process. And so the Self-Help Center is a huge resource in helping people understand how to navigate through the family court system, what needs to happen, how they raise issues, and sort of what the next step will be in the process. So that is certainly an opportunity. I think if you're just trying to dip your toes into the pond of working and volunteering in Superior Court, that's an excellent opportunity. There's also opportunities to volunteer through various community clinics and legal services organizations. So the DC Bar Pro Bono Center, DCVLP, Legal Aid, all assist in staffing essentially advice clinics like the Family Law Assistance Network that are more opportunities if you want to be involved in sort of the direct contact with litigants. That's another way to do it. There's also opportunities for if you're not ready or not able at the time because of your other commitments, your work schedule, to take on a full case, to take on sort of a discrete project and volunteer to help, whether it's on a particular pleading, a legal issue that might need to be addressed, or a particular discovery issue that needs to get resolved, where you could sort of drop in and help for just a limited portion of a case. So there's, to the extent people are concerned either about the extent of a commitment and with everything else they're doing, or just, is this right for me? There's lots of ways to sort of on a very, limited way, get a chance to decide if this is something you're interested in, and then hopefully, obviously, commit and do even more. But family court, I think, has a lot of great ways for someone who has no family court experience to really meaningfully affect the people who are being served by family court.
Judge McClain, you're muted. You're muted.
Thank you. Judge Wellner, some legal services organizations also use volunteer lawyers to provide limited scope services or representation in both family law and domestic violence cases. Can you tell us more about that?
Sure. It used to be that if a lawyer was going to represent somebody in in any case really, they had to be all in. They were going to represent that client for the duration of the case, and there were limited opportunities to escape. I mean, you could do it if you and your client weren't getting along, your client could fire you. And obviously there were certain conflict situations that demanded that you ask to be released, but otherwise you were kind of in it. And that was true of pro bono cases where, sometimes lawyer-client relationships are very, very difficult. It was true in any case at all. And as during the introductions, somebody mentioned that I had been a law firm pro bono coordinator. And one of the things that we were really concerned about was that, a lawyer gets sucked into a case and you can't really predict how much time it's going to take. And it becomes kind of a nightmare. It used to be that landlord-tenant cases here were a real nightmare. And I'm going back 30 years because you'd have to spend all day in landlord-tenant court just to have your case heard for 5 minutes. So there were all kinds of reasons why being all in was scary and problematic, especially for people who, I was going to say, worked for big law firms. I'm sure it would also be true of people who were solo practitioners. So more recently, the rules have changed, and it's now possible to do work for a client on a particular aspect of a case or for a particular amount of time, to stand up in court, for instance, at one hearing. I apologize. I thought my phone would stop ringing. Maybe that will do it. Or to draft a particular document, to draft a complaint. And those are fantastic opportunities for pro bono lawyers. As you've already heard, the need is incredibly great at every stage of the process, because self-represented litigants really have no idea what's going on and how to present their cases and to move forward in any respect with their case. So there are all these opportunities for drafting pleadings, for standing up in court for short periods of time, for consulting with clients before they go into court, that didn't exist before. And if what someone is concerned about is the time commitment that they're making, this is a way to address that problem while still making a huge contribution. There are other ways that were sort of limited scope in the past without being this kind of limited scope for a particular client. Lawyers have always been able to do work for clinics like the DC Bar Pro Bono Clinic, or the Advocacy and Advice Clinic, where you go in for a Saturday morning and then you're out by the afternoon. That's always been possible. And there have been other opportunities like that along the way. But this opportunity to represent individual clients on a short-term basis did not exist before a handful of years ago. And there are certainly opportunities in family court and DV, as Judge McClain just mentioned. And those are also really good opportunities to, as Judge Crane was saying, kind of get your feet wet. If you want, a brief introduction to see how you feel about standing in court in a custody case, for instance, you can do it for a day. Obviously, you have to be well prepared, but you can do it for a day and see how it goes.
Thank you so much, Judge Fuller. Judge Ross, we've been talking about the high volume courts, and the highest volume court of all is the landlord-tenant branch, where landlords file eviction cases against tenants. The vast majority of the tenants are facing eviction are unrepresented, upward of 85%. Are there pro bono opportunities for someone interested in helping tenants avoid eviction but who don't want to be in court?
Absolutely. I'm going to take Judge Crane's lead and also plug my own personal pro bono experiences. When I was a relatively young lawyer, I had the opportunity to represent some clients in landlord-tenant cases in DC. And not only did it give me the great opportunity to actually be able, and I did actually handle those matters in court, not only did it give me the opportunity as a young lawyer to get court exposure, deal with oral arguments and some things that I wouldn't have been able to do as a young lawyer without it. But it also gave me great opportunities to deal with client management, just basic communication in terms of providing information, work on my negotiation skills. But I know the question is a little bit different in terms of opportunities for individuals who may not want to do that and may not want to stand up in court. But I did want to take an opportunity to plug that because it was a great experience and I think anyone can benefit from it. And I likewise didn't have a background and experience in landlord and tenant law before taking that opportunity. But in terms of other opportunities, one good example is the Landlord and Tenant Resource Center. It's run by the DC Bar Pro Bono Center. There are experienced lawyers who have more knowledge about landlord and tenant law who help supervise it. So you're not out there on your own without someone you could turn to for guidance. They offer both on-site and remote opportunities. And something as simple as just providing legal information can make a big difference for those individuals who are trying to navigate and litigate in court without representation. Something as simple as just giving them information on how to ask for a continuance or what other resources are available. Things that may sound very simple to us, but hearing it from someone who's a lawyer, even if they're not a litigator, even if they're appearing in a limited role, may carry a lot more weight and help individuals not to waive certain rights that they may have and to basically explore all of the rights that they may have available to them that they may know about or are afraid to actually ask for, even explore. And like I said, there are individuals there to help guide you and to help supervise if you do have questions. But that Landlord and Tenant Resource Center is a good opportunity for individuals who don't want to actually litigate in court, but don't want opportunities to help in this space.
Thank you. All right. So another area that we don't talk about, and is not a high volume area, but is another area of significant need, is the probate division. And I get to speak about this because I was in the probate division for 3 years. And the number of people that I saw coming in a variety of capacities who really could benefit from some help was remarkable. And so for those of you who are not familiar with what probate is in the district, it's primarily two things. It's individuals who are believed to need assistance in making their own decision making, because either due to like an aging process like dementia or an unmedicated illness, they're not able to care for themselves. And so someone's gonna step in and suggest that they need assistance. There's paperwork associated with that, but the vast majority of what we're talking about in the probate division relates to estate planning. And has someone passed away and without a will or with a will? And how does that process work? Because everyone who passes away in the district needs to have a probate case filed. And so there are a couple ways to help in a very time manageable way to do so. First, the Probate Self-Help Center, which is run by court staff, accepts volunteers. You're going to help people with forms, help them explain to them the processes, help them complete the forms and get them filed, identify other court resources or other areas where they might be able to get assistance. In addition, just last year, a new project was initiated to get people same-day legal advice. And that is the Probate Legal Assistance Network, which is a joint project by the DC Bar Pro Bono Center, Legal Counsel for the Elderly, and the DC Affordable Law Firm. So they're on site at the courthouse 2 or 3 mornings a week, and they can actually provide same-day legal advice for folks who have questions. And so that's the first time that this has been available to folks since pre-COVID. And if you're thinking about, what are the requirements for a will in the district? How do I file a probate case? My sibling is living in this house, but it was left to all of us. What should I do? There's all sorts of basic legal issues, and those organizations that started that project are there to provide substantive resources for volunteers. So there's lots of different ways to also volunteer in the probate division. But I'd like to take another turn and hear from Judge Israel. There's a lot more need for representation in court, and sometimes that comes in the instances of court filing and processes, like I've mentioned, related to probate. And sometimes it comes in other ways. What are some examples of the types of matters that essentially just involve helping someone prepare for filings in court?
Hi, everybody. Good to see you all. And thank you for being here. So I was thinking of two discrete areas where you could pick up representation and assistance and maybe keep it cabined so that you can, kind of manage yourself around that. And the two areas are one, and I'll speak to the criminal piece in just a second. One is assisting people who want to legally change their name or their gender marker. I did not, I don't think I was as tuned into this as I should have been, but Whitman Walker Health Legal Services trains volunteers to assist with that. And in particular, when I got ready for today, it is a packet of information. It is pretty substantial in terms of assisting you in preparing to do these forms. The forms themselves are not overbearing, but there are a number of things that you've got to bring with you, and you've got to meet the requirements. So if you don't bring all the pieces with you, even though the hearing is pretty straightforward, you don't get success. And so the ability of an attorney just to be able to make sure that, I'll call it the malpractice checklist. So in private practice, when we go to trial, we have what's called the malpractice checklist. You cannot leave, you can't rest your case until you've made sure you've covered all these things. Well, it's sort of like the same thing. It's like a little checklist of the things you've got to make sure that the client is bringing and that they have to present to the court. So while there is interaction with the court, the majority of what you're doing there is really assisting the client in making sure that they are doing all the things and bringing all the things that they need. The second area I was going to suggest is sealing of criminal records. So this is a little bit different than expungement. Sealing is done by motion. Well, so is expungement, but set that aside for a minute. The motion, if you think about sealing, is really to take and make private and prevent the public from seeing access to the criminal record in a particular crime. Well, there are eligibility requirements, and they include, without going through all of it, the type of charge you have to take a look at, the amount of time that has passed since the conviction is an issue. Is it 8 years? Is it 4 years? What does it qualify for? What is it, a crime that has been decriminalized or even legalized since that time? So you could envision just taking marijuana or possession of marijuana less than 2 ounces. You could envision folks who have convictions for that who really may be in a position to take action on that. And then you can also prove someone is actually innocent. But here's the thing, I see that the least. The motions to seal, typically the way it works is you're filing that motion to seal. It is not a lengthy extended motion. The part that requires time is making sure the charge isn't, the conviction is an eligible conviction and the proper amount of time has passed. Usually the court will give the government something like 60 days to respond. Most of the time, the government doesn't respond. They don't take issue with it. And so the ability to move that forward, even though it is litigation, most of the time you're not actually going to be in a fight. You're not actually going to be litigating because the vast majority of these, once they're eligible, they're eligible. The second area that you could take on discrete representation is Youth Rehabilitation Act. So if someone has an eligible crime and they're 24 years of age or younger at the time of the offense, and they have completed the YRA requirements that are ordered at sentencing, then they can get expungement. The government gets an opportunity to respond, but they oftentimes don't. Many times CSOSA, which is probation, so that's Court Services and Offender Supervision Agency, many times they will ask the judge, they will say, this person has done everything they're supposed to do under the YRA, and you should now, if you agree, you should now sign off on giving them the benefits of the YRA. God bless you. But not always. And so there are sometimes hiccups where youth, relatively young offenders have completed what they need to complete, or they need a judge to actually sign off on what it is they've done. Let's say they've got 90 hours of community service under the statute, and there's disagreement over whether what they've done qualifies. God bless you. Then you're really trying to help someone getting that expungement off their record in a very discreet, very limited way. And then the last two things I wanted to say was not really to focus on my own pro bono, although we could do that, but I wanted to focus on two pieces. One, what it's like for the client. Just conferring with an attorney is reassuring. Just having an opportunity to talk to someone that understands law is reassuring to them. And then flipping to the other side, from the judge's perspective, it's reassuring to us, because the fact that you're involved means you're likely to focus on what matters to resolving this, whether that is filling out the forms, whether that is standing up and talking to us and explaining the case. We know the minute we have an attorney, you are actually thinking about what it is we've got to figure out in resolution. And so from both perspectives, it is a value add, both to the client and to the court. So I'll shut up, and I've had too much coffee and I'm sorry, but I thank you in advance for your interest, because we need the help.
Yeah, people thank us for participating in these sorts of activities. And I tell you, I'm one of the people that helps organize judges to participate. And all of the judges always say yes. And we say yes because we are here to be of service to our community. And so it's really remarkable, my colleagues on the bench. And one of the ways that we all see the need for service of our members of our community is by getting them more help, because we can only make decisions based upon the information in the record before us. And if that information is incomplete because somebody doesn't understand the process and doesn't understand how to get us the information, then our ability to make decisions is compromised. And so we are happy to give this time to help make the court more accessible to anybody who might be interested in taking on a case, no matter how large or small. Though we will try and get you to come back after you do your first one, because it's just so valuable to the individuals that you're going to help, but also to us as judges to do our job better with better information. So after I get off that little soapbox and appreciation for my colleagues, I have another question for Judge Ross. Mediation is an area where lawyers can build their professional skills. And there are court-based volunteer mediation opportunities as well. And they can be very effective in helping the litigants reach a mutual decision, which will be in their best interest. Can you tell us a little bit more about those?
Absolutely. So one such opportunity is to volunteer with the Multi-Door Dispute Resolution Division. And like Judge McClain just said, mediation is a critical and critically important part of the process for us and for the litigators and for the litigants and the individuals who have cases before the court. And oftentimes it is in their best interest, in everyone's best interest, if they can reach some sort of resolution through mediation. And Multi-Door offers opportunities where they actually train individual lawyers to be mediators. And to serve as a mediator is essentially you're serving as a third-party neutral individual who hears from the parties in terms of their dispute and tries to help them reach a resolution that they can both agree to. And the Multi-Door actually takes the time to make sure they thoroughly train the individuals who are mediators. And in having a conversation with them, I was a bit surprised to hear, but it also makes sense that given the wide range of types of matters that they hear, they have a special need and a special emphasis for individuals who are not litigators to serve in those roles. And so while they certainly accept litigators to serve in those roles, the reality is that a transactional attorney who may have never litigated in their life will have a different perspective and bring more perspective to a contract dispute that is presented to them, and may be more equipped to help the parties reach an agreement or resolve a contractual dispute matter. Someone who is working for a government agency may have a different perspective and bring different skills to a mediation where there is an issue regarding or dispute regarding with a government agency as a party, or issues that involve a government agency. Um, the same is true for just about any area of practice that you may be involved in. Your specialized skills can make a tremendous difference in helping these parties reach resolution, and Multi-Door is very equipped to helping identify what you bring to the table and helping you figure out the best way you can use those skills to help serve as a third-party mediator. In addition to actually serving as mediators, they also use individuals to provide public education and talk about the benefits of mediation, and individuals who may have some legal training, even if you're not a litigator, can volunteer in those roles and help get the word out and help individuals understand mediation a little bit more and the benefits of it, and potentially come in, either choose mediation if it's a choice for them, or come in with a better perspective of mediation and more open to resolution. And they also take what they call intake and referral. They also have an intake and referral program where they'll help parties who haven't even filed a lawsuit yet try to figure out if they can resolve their matter in maybe a slightly more informal way, and a slightly more informal mediation. And they're always looking for individuals that can help out in that too. So whatever your specialized skills are, whatever your practice area is, they can use you, and you can be a benefit to the work of the court and the individuals who may have matters or may not have even gotten to the point where they're filing a lawsuit yet. The DC Court of Appeals also has an appellate mediator program where they actually look for individuals to come in and participate in their mediation program in a little bit different way. They usually look for individuals who can represent clients for the limited purpose of mediation. I know Judge Wellner talked about pro bono opportunities that are more limited in scope, and this is another one of those that will allow you, just for the purposes of mediation during the Court of Appeals, to potentially represent a client, and where you're more so dealing with somewhat negotiation, more client management, and things of that nature, and presenting the matter for mediation at the Court of Appeals, and they have opportunities to do that as well.
All right, so we've shared with you today a variety of pro bono opportunities to help unrepresented litigants that don't involve representing a client in court. But we would be remiss if we didn't also spend some time talking about why you should consider representing clients in court, even if it's outside of your comfort zone. Judge Wellner, can you kick us off for that part of the discussion?
Sure, I'd be happy to, because as you know, that's my pet pro bono project. So, and actually, you know, it's interesting. The name of this session is, you know, ramp up your skills with pro bono. It's not just for litigators. And I've often been involved in discussions like that, where the presumption is that it's not just for litigators, because there's non-litigation work to do for non-litigators. And I have a somewhat different take on that, because, and I actually don't think that's the way this discussion has been so far. I think the discussion about limited scope representation and so forth, that all includes standing up in court. But the point I want to make from my special vantage point, which is someone who was not primarily a litigator when I was at a big law firm, the point I'd like to make is that non-litigators can participate in litigation, can do a great job with it, and can improve their non-litigation skills by participating in litigation. And so my own background, as I said, I was not primarily a litigator when I was at Kirkland & Ellis. I started as kind of a generalist. I did a small amount of commercial litigation, government contracts, environmental. I briefly went to US EPA, and then I came back and I was an environmental transactional lawyer. I was never in court when I was doing my usual practice. But from the day I started at the firm and from when I was a summer associate, I always had one or more pro bono projects going on. And more often than not, they were litigation projects, and they were small, and a lot of them were in superior court. And very often I was always out of my comfort zone, or at least at the beginning I was. And I managed it, and I learned, and there are phenomenal resources available in DC, probably more than anywhere else in terms of mentors available to talk you through, to sit with you, to be with you every step of the way. And there are probably also few courts in the country where the judges are as thoughtful and wise and sympathetic when it comes to relatively inexperienced pro bono lawyers coming to represent litigants in their courtroom, whether it's on a limited scope basis or a full representation. So the even back 30 years ago when I was doing this, although I think the bench was not quite as warm and fuzzy as it is today, and maybe I only think it's warm and fuzzy because I'm a judge, but even back then, I found some measure of comfort in the responses I got to judges who knew that I was in landlord-tenant court or in a small claims matter pro bono, and that I was probably a little out of my comfort zone. That certainly seems to be the case today, based on what I've heard, reports I've gotten. There are obviously occasions where judges are impatient or quick, or you're not prepared enough, or whatever, but that's the exception rather than the rule. And so I think it's very important for non-litigators to not assume that they cannot do litigation. They may not want to jump into it, right away, 2 feet without any net beneath them, but it is something that you can do. That's what I did. That's why I'm a judge today. It started with my pro bono representation in landlord-tenant court and small claims court here. That's how I learned how to be a litigator, slowly but surely over the course of a lot of time, and with great mentoring and great help. So I think that's the point I want to make to non-litigators. Not that there aren't great opportunities for non-litigation work as pro bono lawyers, there is, but I want to make sure that people aren't unduly afraid of doing litigation projects, particularly the kind that we've been talking about here. And I guess I would also say this, just in terms of professional development, I do think that non-litigators can be great mediators and can do a great job drafting complaints and so forth. But I think if you talk to judges, if you really probe this a little bit, I think the truth is you can learn a lot about being a good mediator by having litigated, because you can give people a more clear-eyed view of what their positions are all about, and the same is true of drafting a complaint. You can certainly draft a complaint and help someone draft a complaint if you've never litigated that type of case before, and they'll have a better complaint than they would without your help. But if you've litigated one of those cases before, you know a few things about what should be included, what's not important. And so, just to have a little bit of that knowledge, a little bit of that litigator's knowledge, will make you a better transactional lawyer or a better mediator. And I say that as someone who has lived this. So this is my life. This is my career and my experience. And if there's anything I can pass along, I want it to be that non-litigators should not be afraid of litigation projects of the type that we've been talking about.
So I couldn't agree more with Judge Wellner. And I wanted to highlight a couple of things related to that. One, as part of our committee, one of the other things we do is talk with the judges about the impact that they have when they're interacting with pro bono lawyers, right? There's not an infinite, it's not an infinite resource. There is an infinite need. And so we understand and we share with our colleagues that we need folks to keep coming back in this work. And so that when we are approaching pro bono lawyers, we're approaching them from that perspective. And two, if you're worried that it's a subject matter expert versus you, and that you can't, perform as a subject matter expert would, or a litigator would, that's not how we look at things, right? Any assistance is better. Any level of assistance is better. And we can also, adjust timelines for people as they're coming in new to a case to be able to get up to speed in many, not all, but many circumstances. And so don't measure yourself as, I'm not as good as a litigator, I'm not as good as somebody who knows custody law. Measure yourself against the pro se person who has no legal experience whatsoever, right? You've been to law school, you're adding value. All right, so Judge Crane, some folks, oh, before I go on, would anybody else like to share anything to supplement what Judge Wilner said about non-litigators not, encouraging them to get involved in litigation?
They're all litigators.
Yes, they are all litigators. But we worked at firms with a lot of colleagues who were not litigators. So I was also a pro bono coordinator at my firm. And so we had a lot of non-litigation projects. And also when I was recruiting people to take on projects, I always encourage people to take on a project with at least one other partner. And so I think oftentimes it might be good to take on a project with a litigator and a non-litigator, because you bring a variety of experiences to the table to be able to help. And then having a partner helps you juggle various timelines and responsibilities. Judge Crane. So some folks today might be thinking, I'd like to get involved, but it makes me nervous and anxious. What would you say to those folks?
So many of the opportunities that we've been discussing today, including some of the sort of more limited opportunities, things like volunteering at the Family Court or Probate Self-Help Center, the landlord tenant, clinic, there are things that if you're doing them, you're not going to be thrust in there alone, having to try to, be on LexisNexis looking up what to do. You're going to have trained staff on site who are going to be able to assist you. So it is a huge resource to be able to come to one of those opportunities and know that there's going to be people there who you can ask questions of, who are actually essentially subject matter experts there for you. There are also, in terms of other legal service organizations, that some of these opportunities are coming through, whether it's a DC Volunteer Lawyer Project, Children's Law Center, things like that. They also have resources available. So they're not expecting you to, show up at court and figure it out all on your own. They're there to answer questions, give advice, serve as a sounding board if you have questions. They do trainings. They, as was discussed earlier, there are more formal mentors, as well as sort of less formal mentors who may have just done this before. They may have sample documents or go-bys and things that you can use, so you're not starting with whatever pleading you're drafting from scratch. So there are tons of supports and resources available, meant so that you're not having to sort of devote so much time and energy to this that you're distracting from other things you may be working on. And then there's also opportunities if you're doing it through a firm or through someone at your organization, partnering with someone who's already done one of these before, so that you're with someone who may be able to share their knowledge or experience. So there's none of these, I think, are meant to sort of expect that you are out there on your own and you just have to do this, figure it out and good luck to you. They're all really meant to have resources available to get you steered in the right direction, to make sure you're using your time efficiently. So any of the different opportunities that we're talking about have ways for you to get help. And I think, as Judge McClain had said, trying to partner with someone, work with someone, these are all ways to gain from the other person's expertise and experience. And another just plug is that the doors of Superior Court are always open if you have interest in seeing another proceeding, so that you can at least know what you're expecting on the day you're going to go in there. You can come in and watch. You don't have to watch in person. You can watch virtually and just reach out to the chambers and ask if you can be admitted to observe as a virtual observer. And it will give you a sense, if you're just sort of reluctant or anxious about it, to say, oh, this is how this hearing's going to go. And it may give you some more confidence to realize that this is not as scary or out of your comfort zone as you may think it is. So there, I felt very much when I first took on one of these that this is not something I've never done before. I've never stepped foot in Superior Court. This is overwhelming, but I had the benefit of a pro bono coordinator at the time who was able to sort of steer me in the right direction. And I think all these opportunities we've been discussing really are meant to, as Judge McClain said, get people coming back. No one wants you to do this once, have it be a miserable experience, and you never do it again. It's certainly in the court's interest for people to feel like they know what they need to know and are being of use. So I hope people don't leave here thinking, if I did this, I'd be really, out on my own on this. It's really meant to provide you with the supports that you need to be successful.
Absolutely. Jody, if there are any questions in the chat, please feel free to interrupt me. I do know we have an issue with a link for mediation, which we will follow up on. But meanwhile, Jody put her email address in the chat. And so you're welcome to reach out to Jody. You be on the lookout through the Washington Council of Lawyers or the court website for any of our upcoming open houses, because we've designed those to give you an opportunity to be able to speak individually with judges in a given subject matter area, and also with legal services providers with a subject matter expertise, while at the same time both having court observation and getting tours of the areas of the courthouse. We know it's big and intimidating, so we designed them to be able to drill down into like the specific areas in the courthouse that you need to go to be able to help with certain areas. But if you want to get started sooner than one of those open houses is coming up, you can always reach out to Jody, and she will individually direct you to what you need, where you need to go, or make arrangements for you and colleagues if you would like. So we're going to be unmuting and opening up to interacting with questions, not just in the chat shortly. So be thinking about any questions you have. And meanwhile, I will ask for each of our panel members to give their own perspective in all of the multitude of pro bono opportunities that are available. And that's one of the things that we understand. We've all been in areas where like people get to choose what their pro bono projects are, right? And there's tons of good causes. But why pro bono at DC courts? Judge Wellner?
Well, why not pro bono at DC courts? If this is where you live, if this is the community that you want to be part of, it's a great way as an adjunct to whatever else you're doing in your professional life to be a huge part of the DC community. So it's, your lawyers practicing in DC, you have an obligation, professional responsibility obligation to serve the public. It also happens to be, I think, an ideal place to practice pro bono law, because not only is there need, of course, there's need everywhere, but I think it's also a warm and relatively inviting courthouse with a tremendous amount of thought being given, and I suspect much more than is being given in a lot of other places, to how to make the courthouse accessible to pro bono lawyers as well as self-represented litigants, but also to make the place accessible and warm and inviting to pro bono lawyers.
Thank you. Judge Crane?
Just to sort of follow up a little bit on that, in terms of the receptiveness of judges and the desire for judges to ensure that people have positive experiences in their pro bono opportunities, if you're concerned about timelines or, will I be able to juggle other responsibilities I have if courts are setting hearings on particular dates? I think, as Judge Wellner said, people are trying to be as accommodating as possible on the bench, that if you need more time, if you need a continuance, whatever can be done to sort of make the service that you're giving to the court and to the community work is something that is, I think all of our colleagues are trying to really do our best to understand other people's obligations and what else you may have going on. And so I just, to the extent that anyone's hesitant to say, maybe I have so much going on my plate right now, is this a good time to take something on? I just encourage people to recognize that the judges are going to try to be as understanding and accommodating as possible.
Thank you. Judge Ross?
Yeah, this may be a little bit repetitive, but there really is something particularly special when you are giving back to the community that you are sort of live in or work close by. I think as lawyers, a lot of times our lived experiences are very different than the litigators or the litigants, I should say, that are appearing in these cases and that really need pro bono help. And having an opportunity to connect with those individuals and making a difference in those particular individuals who may only live a few miles from where you live, but have a very different experience than you experience, is particularly rewarding. And then, like others said, and what we've covered today, there are lots of different opportunities that can cater to different types of interests where you can get involved.
And Judge Israel, anything you'd like to add?
Two quick things. I was thinking about this concept of ramping up your skills, but one thing, well, two things we didn't touch on. One, I think it's important, particularly at the early stages of your career, to work on building your reputation. DC is a very big legal community, but yet in some ways it operates like a small town. And in part, that is because of reputation and networking. With respect to reputation, if you only do things inside your organization, you cannot build a reputation across the greater DC legal community. You have to step out professionally in order to do that. And pro bono is a spectacular way to do that because it gives an opportunity for people to see you in action professionally outside your organization. And dovetailing with that is building your network. I still believe very strongly that the practice of law is an apprenticeship. And the way we learn to be excellent at our jobs and excellent lawyers is by being around really smart, excellent attorneys. Building your network in this town is incredibly important. And I don't think you can do that. You can build a network inside your organization, whether that's a section of the government or a law firm, but your network is constrained to that organization. If you want to build a network for opportunities and growth throughout your career, you've got to go outside your organization. And this is a really superb way to go about doing it because it checks so many of the boxes. All right, I'll share.
Thank you all so much. Does anybody have any questions that they want to ask us? Let's see. Nobody's speaking up. So this is one of the things that made me very surprised when I came to the court is how reticent it made people to ask me questions. So if I want somebody to give me a straight talk, I have to go to somebody who knew me before I was a judge. So I very often go to those folks, or I go to my colleagues who are always willing to help.
Judge McClain, I did see Jillian, I'm sorry, Ambrose had her hand up, but no, okay, put her hand down, never mind, sorry.
Okay, all right, thank you. All right, so I just wanted to, I can close out with some final thoughts that if you don't want to step in a courtroom, you don't have to, but you can still help your community members in lots and lots of different ways here at Superior Court, and they really need your help. And they will really value your help and it'll be very rewarding. And I'll give you a war story, which was in a litigation context because it was landlord-tenant, but I really didn't actually even go to court in the case. I took on a case before I became a judge, representing a father of 4 children, a single father of 4 children, worked full-time, still needed subsidized housing, had some serious housing conditions, so withheld his rent. Landlord sued him several times. He had trouble navigating the system. I stepped in to help. All I ever did was negotiate with the landlord's lawyer and come up with an agreement that I thought was fair to my client. And my client walked away with an entirely new apartment that didn't have mold, that didn't contributed to his son's asthma. He walked away with some penalties that came through in the contract when they didn't follow through with their end that helped him start saving for a down payment on a house. For none of it, I stepped into a courtroom. For all of it, I got to deal with this really kind man who was just trying to be a good dad and live in a healthy apartment with his family, and only involved negotiating a contract that was fair to him. And that is all I have today. I hope you all will get involved. Please, please, please call Jody.
Thank you, Judge McClain, and thank you to everyone on our panel. I know we just have a few quick minutes left. So I will say the most important thing first, which is if you want to follow up on anything you heard today, if you want more ideas, more information, want to know who to reach out to, who to connect to, who can help you get involved in volunteering, please reach out to me. That's what I do here at the courts. And I've put my email in the chat there. So please don't hesitate to reach out. I'm happy to speak with individual lawyers. Also, if you're here representing a law firm or you work at a law firm and you would like a judge to come speak at your law firm, you would like to bring your summer associates or your fall incoming associates to the court for court observation to meet with a judge, we can arrange all of those things. So we really try to personalize the experience, whether you're a solo practitioner or working at a large law firm, to try to educate you about the opportunities available and find the right fit for you so that you can help us out. So please don't hesitate to reach out to me. Just a couple of things. This is the second in 3 installments of this Perspectives from the Bench series that we are doing with the Washington Council of Lawyers. The next installment is on April 1st. And you can already register. You just go to the Washington Council of Lawyers website and the information is up. It's a little bit of a twist. It is more litigation focused in that that will focus on what judges would like you to know when you are litigating against someone who does not have a lawyer. That's a very, unbalanced, different type of situation. And there's particular things that are important for you to think about when you're in that situation. So please join us if you're interested. Tell your friends and others. Also, as has been mentioned a few times, we host regular events. We host regular open houses that are also available. Information will be available on the Washington Council of Lawyers website. We should have some coming up this spring. And on March 19th, we're having a very special pro bono fair event here at the courthouse. We have over a dozen legal service providers lined up, as well as several of the court programs that you heard today who will be here tabling, and you can come and talk with them and get more information about how to get involved. Our chief judges will be there, as will the DC Bar President, Sean Snyder. And so you'll also have a chance to chat one-on-one with judges as well. So I will, I don't have the link for that just yet, but I will send information about that event, and we will also advertise it in probably all the same places where you found out about this event. So I will stop there, but again, we're here to help you, help us. So please don't hesitate to reach out to me about anything that you'd like to follow up on from today or anything else related to pro bono in the DC courts. Thank you so much.
Yes, thank you all so much for coming today.